All right, good morning, everybody. Thank you for being here on a Friday morning. Really appreciate it. And I apologize, there was some confusion. We originally planned this meeting over in the boardroom. It got moved over here, so there might be some people that come in a little bit late. I know there's a group that already came in. There might be some more people coming in. But welcome. My name is Nick Stephanie. I'm the HR director here at LACOE. Aster Gonzalez, another HR director at LACOE, is going to help us out today. But these are the topics we're going to cover. Basically, what we want to do is provide a two times a year meeting to talk about updates in laws, policies, and best practices that will help you be better managers. Okay, we get a lot of questions that come through labor relations and HR, and we're going to try to focus on the big ones in these meetings. Not just so you don't ask LR questions. We're happy to answer your questions, but at the same time, a lot of these things are really crucial so that we get them right in the first place going forward. All right. So we're going to start, just a little bit about myself. I was a high school chemistry teacher, but more importantly, a JV football coach. All right, so how does any self-respecting JV football coach start class on a Friday? He shows a video, right? All right, so this is a great video. This guy's name is John Maeda. Has anybody ever heard John Maeda by show of hands? All right, so really interesting man. He was a Fernando, you have not. All right, so he was an MIT math professor at like the age of 27. All right, so very, very intelligent person, really into math. That's incredible. And you're set for life if you're a tenured math professor at MIT. He left that position to become the president of RISD, the Rhode Island School of Design, which is totally on the opposite end of the spectrum than math, right? It's a design school. And he started getting really into talking about creative leadership and how do we look at leadership in different ways so that we can kind of rethink our organizations to do better. So what I want to kind of keep in mind through this video is as we go about at LACOE, as we go about implementing these new laws, these new policies, best practices, it's not so much what they are, it's how we implement them. It's our interactions with our employees, it's how we deal with our employees, how we talk to our employees that make this path a lot easier to go down, okay? And what he talks about a lot is not so much storytelling, but story listening. So we'll start the video and then we'll do a quick activity.
Thank you, everyone, for taking the time to exchange ideas. So we hope there's a wonderful opportunity for you to hear a little bit about what your colleagues are thinking with regarding to the importance of story listening. So now we're going to have the workers' compensation and risk management team come up, and they are going to be sharing some valuable information with you regarding this topic. So I'd like to introduce James and Tina.
Hi, good morning. Thank you all for coming. Appreciate your time and attention today. Our leader, Lucretia Bridges, is the Chief Risk Officer for LACOE. She couldn't be with us today, so we will be covering her portion of this presentation as well. And what we have up on screen now are the links that hopefully you've already received, but these are for the various forms that we have, and including are also the employee orientation slideshow. So I think we'll get started. You see our names up here, and okay. Besides workers' comp, which is the bulk of what we're going to be speaking with you about today, risk management also covers a number of other areas. And so the first one that we usually lead with is insurance, and that's the most common perception people have when they hear the term risk management. But just if you think of it, group it all together, our goal, our purpose actually is to make sure that the entity's assets are protected, and the most important asset, of course, are the people, the human resources. Now, we do it in a variety of ways, though, and one is through insurance procurement, and that includes a student accident policy that we buy every year, and also property and liability insurance. We go out to the market, and that is renewed yearly as well, and certificates of insurance for any vendors doing business with us, vendors or contractors. We also are very concerned, obviously, about staff and student health and safety. We have a field trip safety training that we can do, and we have a staff person who is responsible for the occupational workplace safety for all of LACOE. and that individual puts out the policies and procedures, including the injury and illness prevention plan, which is required by state law, but we've been ahead of that for many years. We also have the chemical hygiene plan, heat illness prevention plan, utility cart safety, the hazardous communication plan update. And today, for those of you who work at this location, you may or may not be aware, but we have the utility shoe program, and that's going on right now. So we're very excited about that. But you can get more information about what risk management does, including the workers' comp, from those links that we just talked about. So what is workers' compensation? Workers' compensation is a California state mandated insurance program. All employers in the state, even if they have just one employee, have to carry workers' compensation. It provides benefits to employees who suffer work-related injuries or illnesses on the job. And more importantly, it's a no-fault system. And what I mean by that is people these days still have the perception that, well, if my staff person that filed a claim, they were doing something stupid or that they shouldn't have been, and so why should we be paying for all of that? Well, it doesn't matter. If it happened, if it arose out of employment or happened on the job, we as LACOE, as the employer, we're on the hook for the workers' compensation. Workers' compensation benefits include medical treatment. LACOE has a medical provider network, an MPN. Employees must seek medical treatment within our selected medical providers unless the employee has a pre-designated medical doctor prior to the date of injury. Now, that's a separate form that's required, but if someone's interested in doing that, we can assist with that. But it does involve, though, going to a doctor and having the doctor sign off on it first. And it has to be a doctor who, if God forbid they do end up getting hurt, but it has to be a doctor who treats that particular type of injury. The benefits also include temporary disability benefits, which are provided for accepted claims if the doctor states the employee cannot work or LACOE cannot accommodate the temporary work restrictions. Then we have permanent disability benefits if the injury to the employee causes permanent disability. Supplemental job displacement benefits, these are provided if the injured worker has a permanent disability that prevents the employee from returning to work and the employer does not offer, that's us, a modified or alternative job. And lastly, there are death benefits. These kick in if the injury or illness of an employee results in death. These benefits may be payable to family members who are financially dependent on the deceased worker. Okay, next we have a list of the forms here. These again are in the links. The most important one I want you to remember is the second one down. It's the DWC-1 form. This is the workers' compensation claim form. The whole process has many time-sensitive deadlines, and this is the first one. We as the employer, you as a supervisor, once an employee comes to you and tells you they've been injured, you have 24 hours to get them this form and then get it into us. There's also the 5020, the employer's report of industrial injury or illness. This is something that the supervisor or someone other than the employee himself or herself needs to complete. Then we have the Gen X Harbor Health Brochure, the Employee Incident Report. That one's important for any claim, but also you occasionally will get someone who has been hurt and they tell you that they don't want to get medical treatment. When that happens, they still need to file the Employee Incident Report. The medical authorization form, that's very key in getting people permission to go get help to wherever it is in the MPN they need to go. And the pharmacy first fill form, and lastly, the supervisor incident report. This also must be done if in that scenario where someone doesn't want to get the, medical treatment. We ask that you do that. And again, I mentioned already that within 24 hours of our knowledge of an injury, you must provide the employee with the following forms: the DWC-1, the Employee Incident Report, and the Gen X Harbor Health Brochure. Okay, employers are not mandated to file a claim. However, if they wish to file a claim and seek treatment, they must complete the DWC-1 claim form. If they simply want to report the claim and not seek any medical treatment, they only need to complete the Employee Incident Report. As a supervisor, you can't insist that an employee files a claim, nor can you deny them the opportunity to do so. Provide them with a Gen X health brochure. If it is an emergency, please call 911. If it's not an emergency, the employee can seek medical treatment through the LACOE Medical Provider Network facilities or their own doctor if they have completed a pre-designation form prior to the date of injury. Oh, and regarding transportation, if you have somebody who does get injured, we don't recommend that you take them.
Sorry. If somebody's severely injured, you want to call 911 and the employee refuses to go with the paramedics, obviously we can't force them, but the point to remember is we cannot transport that employee to urgent care, hospital, or whatever. They need to call either a family member or friends. Other than a LACOE employee, we cannot transport them because that creates a liability for us. So you can follow them in your own vehicle, but you just cannot transport that employee who's been injured. Question? No LACOE employee can transport the person who was injured because we're all covered under the same liability, so we don't want to go that route. Any other questions? Okay, I'll give it back to Jim.
Okay.
No, carpooling is okay. It's just in the event of somebody who's been injured who needs to go seek treatment, we just don't want to transport them. You're talking about a non-emergency situation? That I don't know, but I'll get the answer for you. Okay. I'm sorry? That, go ahead.
In that particular instance that you described, if it's in the course and scope of your employment, and you're both assigned to this and you're both going together, then you're both eligible for any workers' compensation benefits that might be coming to you.
Okay, no problem.
All right. The next one. Yeah. Okay, then we would like you to complete the medical authorization form and give it to the employee to take to the medical facility or doctor that will be providing the treatment. This form authorizes the employee to be treated under workers' comp. Next, we have the pharmacy fill first form. This is so they can get prescriptions covered. Then the employer's report of industrial injury or illness, that's the 5020, should be typed and printed legibly and signed by the supervisor or the administrator. The employee should not complete the 5020. Lastly, complete the supervisor's report. This form should be signed by the supervisor or the administrator. Once all the forms have been completed, you can send them to us at the workers_comp at laco.edu or 562-469-4317 by fax. Okay, so okay. If you have reason to think that the injury did not occur at work or may not be as reported by the employee, please be sure you let the workers' comp unit know your concerns. LACOE has a duty to conduct a good faith investigation to gather the facts about an injury. We will sometimes use the services of a private investigator to assist with the investigation. If an investigator comes to your site and you are unsure they were sent by LACOE, contact one of us immediately, and we'll let you know if they should be there. In the past 3 years, LACOE has seen 7 cases resulting in the prosecution successfully of fraudulent workers' compensation claims. That's something we take very seriously. So we just want you to be aware of that. Okay. California Labor Code Section 132. First of all, the Labor Code is what governs everything about workers' comp. But Section 132 of that code refers to the protection of injured workers against discrimination by employers for having filed workers' comp claims. This section is applicable to any step in the workers' comp process. Violations of 132A by employers can result in a separate cause of action by employees subjected to such discrimination. Separate being anything they might be entitled to for workers' comp. It doesn't come out of that. It's a separate physical cause of action or financial. After the initial workers' comp, actually, at this point, I'm going to hand off to my colleague Tina.
Good morning, everybody. I think I know most of you in this room, but if anybody doesn't know me, I'm Tina with the longest last name at LACOE, Megradician. And just type in MEG and I'll pop up on the directory. Anyways, I'm here to tell you a little bit about our return to work program we have that's within the workers' comp department. But before we get started, I wanted to go over a few laws that are very important when it comes to reasonable accommodation and how we can get our employees back to work. If you can go to the next slide, please. Thank you. So the first one is the American with Disabilities Act. This is a federal law that governs reasonable accommodations and getting people back to work. In 2008, they came out with what's called the ADAAA, which defined the law even further, talking about what is considered essential functions of a job, what is a major life activity. The second law that we mostly comply with, it's state mandated, it's called the Fair Employment Housing Act. It's called FEHA. So most of us, if we comply with FEHA, we're already complying with the ADA. And then lastly, as Jim had mentioned, we in the workers' comp arena, everything's governed by our labor code, which and then in turn, they also comply within both ADA and FEHA. So as I said, if we comply with FEHA rules, we've already met our obligations under the ADA. And so what are these laws? Why are they important? What do they tell us? So what they mandate is that we must engage in a timely, good faith interactive process. Unfortunately, the law doesn't define what is timely, but we know what good faith is. We have to try. So as far as timeliness goes, if I'm on notice that an employee needs reasonable accommodation, if I schedule a meeting within a week, that's reasonable. But if somebody sits on it for months at a time, that's not reasonable. And the judge is going to basically ask us, so what happened? You denied the employee with the opportunity to come back to work and engage in a dialogue with them. Number two, employers, I'm sorry, Jim, if you go back. Employers must consider reasonable accommodation. So I've met with most of you in this room. My philosophy is there's always a will, there's a way. We have to think outside of the box. I don't accept, no, we can't accommodate. We have to talk about it because this gets documented, and if the employee files a suit with FEHA or ADA, we need to defend it as an employer why we couldn't accommodate. So I encourage everybody in this room, put their thinking cap on when it comes to reasonable accommodation. So the interactive process is the mechanism that we're going to facilitate and bring back our employees back to work via reasonable accommodation. If you hear that word thrown around a lot, what is interactive process is basically an informal dialogue between the employer, management, employee, and if they wish to have their union steward or representative at the table, we welcome that, so that we can talk about what is reasonable accommodation and getting people back to work. All right, now let's go back to the return to work. So Jim had covered as to the whole process. Somebody gets injured, they say, hey, I want to file a claim. We give them the paperwork, they file out the paperwork, we give them a medical authorization form, they go and seek treatment. The employee will have some sort of a paper, a work status report, something from the doctor when they come back. The doctor will have one of the following three choices. The employee is well enough to come back and resume with their regular assignment, great. You get that slip of paper from them and they can go ahead and start with their regular assignment. The doctor may also say, you know, the employee sustained an injury that's going to require them to come back to work with some temporary work restrictions. I should have a copy of that report, but if I don't, if you guys want to fax it to me or email it, then we can at least have a dialogue either in person or via conference call as to what we can do to accommodate this employee with these temporary work restrictions. If it's a simple accommodation, we can tell the employee, hey, we can accommodate by A, B, and C, come back to work, and then you will follow up with your doctor whenever the doctor deems necessary, another 2 weeks or 3 weeks, and then we can revisit it. If it's a complicated enough accommodation, I will usually schedule a face-to-face meeting. Again, myself, you as management, the employee, and if the employee wants to have representative at the table from their union, that's fine. We'll sit down and dissect what the essential functions of the employee's job is and how we can accommodate. Now, let's say the restrictions are so severe that we can't accommodate them at their current position, then we look at light duty positions. So in the past 10 years, I've connected with a lot of divisions and departments here at LACOE who need light duty help. Perhaps somebody tells me, oh, you know what, I need somebody to come and help me shred some paper. I need somebody to go do some filing for me. I need somebody to answer phones. Great, I'm gonna get that employee and I'm gonna bring them back to that area. They can work in that light duty transitional work up to 90 days. You don't wanna go past 90 days because it might then be perceived as permanent work accommodations, and that might violate some job classifications, and we don't wanna do that. But up to 90 days, we can certainly bring the employee back to work in some capacity. I'm sorry? Yes. The third choice the doctor may make at the evaluation is, okay, this employee has had a severe injury. I do not want him or her go back to work. So they're going to place them off work completely. That's fine. Obviously, we have to allow our employees to stay home and recuperate. So now a little bit about timekeeping and payroll and coding. So on the onset of every claim, we consider that delay period because what we're trying to do is fact-finding. Us, along with our third-party administrator, which is York, which is now called Sedgwick, by the way, we're doing fact-finding. We're getting medical evidence, we're doing interviews, trying to see if this claim is compensable or not. So while the claim is on delay, if the employee is off work for whatever reason, either we couldn't accommodate or if the doctor places them off, their time needs to be coded as PIN in Nova time, pending industrial time. That essentially means that the employee will get paid, but they're going to get paid out of their own sick time. If later on the claim gets accepted as a compensable claim, we will go back retroactively and amend that sick time and credit it back to the employee. Now, if the claim is accepted as a compensable claim, if the employee is off work again for whatever reason, now the claim needs to be coded as industrial time, IN. It's in Nova time. The employee cannot mark his or her own IN time. The timekeeper will have to do that, or you as the manager. Any questions so far regarding timekeeping and all that? All right. So let's say the employee comes back to work, but they're still required to go to doctor's appointments, physical therapy, MRIs. We have to allow our employees to go to their medical appointments. We ask that the employees make their schedules either with the doctors either in the beginning of their shift or latter part of the day so it's not disruptive to business. If you see a pattern that the employee keeps taking off for these doctor's appointments middle of the day, they're not returning, let us know. It's as easy as us calling the facility and making some arrangements that is best suited for the business, okay? Again, if the claim is accepted, we'll code them IN. If the claim is delayed or even denied, we'll code it as PIN for that time that they're missing away from work. So there's going to come a time and point that the doctor is going to discharge the employee from his or her care. When that happens, they might have some permanent work restrictions, which I will receive, and then I will reach out to you as the manager or the supervisor so we can sit down and have what's called a formal accommodation meeting. This is when it gets serious because these are permanent accommodations. What happens if we don't accommodate the employee? I will have to direct the employee to stay off work. At that point, they're probably going to use their own sick leave. If they don't have sick leave, they're going to dip into their 100 days at 50%. If they don't have that, vacation time. And if they're eligible for FMLA, which my colleague, Dr. Castor, will go over, they might get FMLA, but it might be unpaid. So it's really important to see if we can accommodate folks and bringing them back to work. There's been a few instances that we haven't been able to accommodate permanent work restrictions. In those scenarios, I've worked with Personnel Commission. I've looked at the employees' transferable skills to see what other kind of jobs they may qualify for at LACOE so that we can help them get back to work. That's about it as far as accommodations. As most of you guys know, I also do ergonomics evaluations, whether it's on a preventive, proactive basis or whether it's been dictated by workers' comp. Call me and I'll come out and do the assessment. One last thing before I forget. So we here in workers' comp, well, I do accommodations that are warranted from a workers' comp claim, okay? However, if somebody has restrictions that are not work-related, they're non-industrial, they present you with a note from their own, private doctor, contact labor relations because they will also have a similar process as far as interactive accommodations, and they can help the employee come back to work. Okay? Any questions? All right, thank you for your time, and if you guys need anything, give us a call.
Thank you, Tina and Jim, for deepening our understanding of workers' compensation. We appreciate it.
Thank you.
So now we're going to learn more about family and medical leave and California Family Rights Act. Let's welcome Dr. Faz Basari.
Thank you. Thank you. That's not what works. Okay. Okay. Good morning. My name is Fazile Kasri. Everybody call me Faz. I work for HRS, and I handle leave of absence. And this morning, I'm going to talk to you about family and medical leave. What is family and medical leave? It's a leave of absence that is protected federally. That's how it's called, family and medical leave, and also statewide, the California Family Rights Act. And for LACOE, they run concurrently. Okay, so family is a leave of absence. It provides the employee for up to 60 work days of unpaid leave with no threat to jobs and benefits. And the leave may be taken on a continuous basis and on an intermittent basis. So for example, an employee have surgery, they can be out for 3 weeks on a continuous basis and then take intermittent leave for follow-up appointments, doctor's appointment, and treatment. Okay, so how are we eligible for FMLA? The employee must have worked for LACOE for at least 1 year and have worked at least 1,250 hours or 60% of their annual assignment prior to the start of the FMLA. Okay, next please. FMLA reason is to care for a dependent, and for dependents for FMLA purposes are child, parent and spouse, or the employee themselves. They are sick. The reason. Next, thank you. Do you remember intermittent is when you don't take your leave on a continuous basis, for example, 2 days per week. That's intermittent. So the employee must inform supervisor whenever possible. They must inform their supervisor of their, upcoming absences. If they cannot, warn you ahead of time, that morning they have a flare-up, they are very sick, they cannot move, someone needs to call you, them or a family member needs to call you to let you know. And at the report FMLA absence, I've noticed that some people get, approved for intermittent FMLA, and then the employee report their absence directly in NovaTime. If you have been approved for FMLA, you need to use a paper absence claim, and often an employee just go to NovaTime and report their absence without warning their employers, their supervisors, that it is an FMLA absence. Down the road, it can be a problem. Okay, next. Okay, so FMLA is an unpaid leave. However, LACOE has its own leave system, leave of absence. We are provided with sick leave, 12 hours as of July 1st. And then we are also provided approximately 800 or 50% sick leave. So you can use FMLA, or your employees can use FMLA with paid leave as follow. So if the employee himself is sick, they can use sick leave or vacation in lieu of sick leave. And if it's due to a dependent, they can use a PN, personal necessity leave, AB 109, which is kin care leave, and vacation. Next, please. Okay, so when should you refer your employee to me? If an employee comes to you and say, I'm pregnant, I'm going to have a baby, I handle all leave of absence. So maternity disability, you refer them to me. If they say they're about to have surgery, or their parent, spouse, or child is about to have surgery, or being sick, refer them to me, okay? So I can decide if they are eligible for FMLA. By law, we have to let them know of their FMLA right, and, so that's it. I think that's it, right? Mm-hmm. That's it. If I have any questions, sure. Or state disability. Okay, yes. So we do not pay into, this is not FMLA. This is just paid leave, right? Yeah, disability. So we do not pay into state disability. Instead, LACOE has its own leave system. Every July 1st, you are advanced 12 days. If you're a teacher, I believe it's 11 days, but 12 days at full salary of sick leave. Additionally, approximately, you also are advanced 800 hours at 50 half pay, 50% sick leave. And that's how you get paid whenever you're sick, FMLA or not. Yes, first. Correct. And also, if you are not a teacher, LACOE member do not get this, but all others do get this, is you also accumulate. You are not advanced, you are accumulate vacation. So if you're on paid status approximately half the month, at least, you accumulate vacation every month. You can if you wish, yes. No. Mm-hmm. Okay. Anybody? Yes? You have to ask payroll. Yeah, because it's different and it depends when it is. Okay, yes. That's right. So let's say you do not use your 50% at all. You just use 5 days of your, 100% sick leave as of June 30th. July 1st, the 800 you had before disappear, you get a new set. Okay? Yes? That's right. it depends on the salary, and for some salary group, it's not only be, based on how many days you get, but also the rollover, and often the rollover plus 12 days. It's different for every salary group. That's why I say approximately 800 hours. If you want more information about that, please contact me. I know I have a whole table for it, so I can give you, tell you what your situation. Anybody else? Okay. Thanks. Okay, sure.
Thank you very much, Paz. We appreciate you. So now we're going to be talking about reference checks. So an update regarding reference checks is that every employee, whether it's classified, certificated, management, or just in general, who comes to LACOE needs to go through a reference check. So that's something new. I know before it was more certificated, but classified also. So as I mentioned, part of the hiring process and one of the most important aspects of the recruiting and the hiring and selecting someone to work here at LACOE are the reference checks. So one of the things that we learn when we do reference checks is we learn if that person that's wanting to work for your team or for LACOE is a match. Is what they put on the application, is it valid? So one way to verify it is to contact the references, and then you can then you'll find out whether or not they're going to meet all the requirements for that particular job description. Also, there's past performance is a very strong indicator of what their performance will be like here at LACOE once they are hired. So under California law, any conversation that you have regarding references is privileged. So whether you're giving a reference for someone or whether you are calling about a reference. So the only conversations that are not privileged is if the conversation leads to topics about an employee's protected rights, meaning protected speech or activities, then it's no longer protected by the law. So we want to make sure that any conversations are not leading to defamation of character, and they're specifically targeted on the person's qualifications and things like that. So some of the conversations that wouldn't be privileged, for instance, discussing if that future employer or new hire was involved in any bargaining unit or union, any organizations or topics about religion or things like that. So at the end of each table, there is a copy of the LACOE policy regarding reference checks. So if you can, those of you at the end, if you can take one and for yourself and then share them with your colleagues. There was a question. I saw a hand. Right here? Yes. So the question is, if there are references that are negative, can we give those references as long as we're not discussing the things I mentioned, protected speech or activities? Are they protected? So they're protected in the sense that as long as you're not discussing things that have to do, for example, if they were dismissed for a particular reason, those are things that labor relations or HR would have that. We would be able to have certain discussions, but there are parameters. But you would not. You would just limit your conversations to their job performance here, right? What they did in terms of how long they worked here, their job functions, and if they were to ask you, would you hire them again? Then you can honestly say, if it's no, no. So they were dismissed, and we would need to. Then, yeah, we would have to have that discussion. So, James, am I clear? The question is, if someone were dismissed, a regular supervisor would not be having those discussions with an outside employer, correct? Right, HR and labor relations. Yeah. Great question, thank you.
Yeah, I think it was similar, and I think it just the way I was a little confused because maybe it was a rumor, that you can't say anything negative, and if you say anything negative, that it should have been addressed in employee performance issues. That's kind of what my understanding with previous employment was. Because sometimes even as management, our employees move on, and then we're asked for a reference check, and what are the limitations of what we can share. So my understanding of what you're saying is we can say they worked here, this is what they were responsible for, but not necessarily say this is how they performed. And if they ask if they were dismissed, why are they no longer working there? We
Right.
have to be very careful.
Exemplary responses, yes, those type of conversations with the new employer who's trying to hire them would have to take place with HR, labor relations. Yeah. So this particular document that I just shared with you, actually one of there are 7 steps when you are asked for a reference from, for instance, from a colleague here at LACOE or a colleague outside of LACOE. So the first thing is if you don't really know that person who's asking you for a reference, you want to call labor relations and just get a little more information regarding that person before you give a reference, because since you are a LACOE supervisor, you are endorsing that person. So these steps do outline, for instance, what we just discussed in your references, in your letter of recommendation, whether they're verbal or written, just explaining how long the employee worked here, what, if you're talking about strengths, tie them to the job that they did. And at the very end, steps 8 and 9, make reference to using putting your letter of recommendation on LACOE letterhead and what that means and who can and how when you use when you can put the letter of recommendation on a reference and when you can't. For instance, if you're a supervisor who directly supervises the employee, you can go ahead and put it on a LACOE, the recommendation on LACOE letterhead. I saw a hand raised. Yes, question.
So if I am rehiring somebody and I am their reference because they worked for me previously, do I have to fill out this form myself?
So you're asking about internal candidates?
So no, they left and they're coming back.
They left.
They left and they were gone for over a year, and they're reapplying to come back because there was a vacancy, and so they're going through the whole hiring process again. Assuming that they get to the end.
Oh, yes. If they're not currently LACOE, they left and came back, yes, you would need to have them.
And I'm the reference.
Yes.
Okay, so I would fill it out for myself.
If you're the only reference?
No, but like I'm one of 2.
Oh, okay.
So like I'm one of 2 and it requires 2. So I would fill this out.
So I mean, if you're the reference yourself, no. If you're the one, no. Yeah, if you're the one who wrote it, no, you don't need to do that.
Okay.
Yeah, because you're the one conducting the reference check. Yes.
Right.
I thought if someone came back.
No.
No. If you are conducting the reference check and you're giving that person a reference, no, you don't need to fill out that form.
Okay.
Yes. Clarification. Sorry about that. Yes.
Number 5 says you must have a good reason to believe the employee will be a good employee. If you believe that they will not be a good employee, you see that they're standing in the job, are you still required to provide a reference, or is this based on not meeting the
If someone asks you for a reference?
if in the event that it is?
Okay. So the question is, if someone asks you for a reference and their quality of work isn't what it should be, you do not need to give someone a letter of reference. That is your decision. Yes. Okay. Any other questions regarding letters or letters of recommendation or references? Okay. Okay. So the process for reference checks, and someone just mentioned it, 2 reference checks are required. And so if the employee who we're hiring is an internal candidate and you already know that employee, you worked with them, for instance, they're from your division, there isn't a formal process. You do not need to fill out the formal reference check forms for them. However, it is recommended, though, for instance, if you don't directly work with that person or you've never worked with them and they're from LACOE, it is recommended that you still have a conversation with maybe their previous LACOE supervisor to get a sense of their work and their achievements here at LACOE prior to hiring. but it's not absolutely required. Okay, so I will show you the forms. So you have these two forms at the end of each table. There are forms, so the person at the end of the table, if you can share these with your colleagues. So the form to your left, that is the one that you use to do the two reference checks, and they're fillable. So you can type your the information that you get from the reference, and then you can email it to me or to Nick, and so we'll send these to you. And the second form is just confirming that the process was done. We need both of these forms for certificated staff that's being hired in order for us to make the job offer and to hire the person. So this is required. And for classified staff, this form, you can get it from the Personnel Commission. So they have a packet that they give you for the hiring process. So these two forms, the one on the left will outlines the process, and then there's a checklist that you would use. So any questions? Yes.
Actually, just to inform you, we're actually looking at updating the reference section for the classified. So as soon as we have a final check. Actually, Personnel Commission is in the process of updating the classified reference request form. And so once we have that ready, we will distribute to the organization.
Thank you. So two questions that are asked very often. The first one is, if someone does not indicate that if you happen to know a candidate and you look at their references and you notice that, for instance, there's a district or there's a previous employer that you might happen to know, but they didn't list that particular name, but you see the company, you see the district, and you might know someone, or someone on your team knows someone from that particular company or district, you can still contact them and do like a backdoor type of check. And that's okay. Because often we'll get a phone call and, oh, I knew someone that worked for Alhambra Unify that might know this person. Can I call them? But that person isn't on the resume or and it isn't on the reference list of people that we can contact. So you can contact them. And the second question is, and there's a scenario for this, is what if the applicant says, please do not contact my current employer. So if they're at the point of the process of the interview or the recruitment process where we're going to make a job offer, that is a condition for employment. So we need to make the candidate aware that we need to call that particular employer or the recent employer. Okay. So the process is that for certificated staff in particular, is that the reference checks are done, and then the division director and the cabinet member who oversees that division approves the new hire, and then the job offer is made. So we have some scenarios. At the end of the table, you'll find the scenarios. If you can take one and share them with your colleagues. And so please go ahead. Yes, question.
I do have another question. So given that the reference checks are privileged information, I know historically one of the people, when I called the reference, they're Spanish speaking only, and I don't speak Spanish. What should I do in that situation?
Okay, in that situation, if you're the manager who's hiring, you can have someone else since they're privileged, you can go ahead and contact me. I'm bilingual, and I will help you. I will do it. I speak Spanish. So just go ahead and call me, and I can go ahead and help you, or we can figure out if there's somebody else on your team, a director or some other supervisor who's working with you who also speaks Spanish. They can also. But I will be happy to do that for you. No problem. And okay, so the scenarios. So if you can go ahead and, with the partner, go ahead and talk through those scenarios, and then we'll come back together and share out what your thoughts are about those scenarios. Thank you. Okay, thank you, everyone. I could see you're really, I'm listening to your conversation, and I see that you're coming up with, generating some great ideas. So, so let's talk about question number one. So you call about this person and you're wanting to hire, really excited, and then they say that they would hire the person or they would rehire the person, or depending on, what position, right? What the position is. So it's a lukewarm reference, right? It's not stellar, it's not, and this is the person when you want to hire. So what would you do in this situation? What are some ideas? What can we do?
Call the person, ask why, because maybe the person is still working and doesn't want to know, doesn't want her management to know that she's applying or he's applying for the position.
Okay. So, so you're saying question. Okay, so she's responding to the question regarding when you have someone who doesn't want the current employer, right, to be contacted. What do we do in that case? And we had mentioned that that's a condition for employment, right? And a lot of times, maybe that person's in a situation where um, they're not in the best situation, but they're doing a pretty decent job. So we just need to talk to the candidate and let them know we're really, really interested in them, and that to make that final job offer, we need to contact their supervisor. But we ourselves would understand knowing that maybe there's a situation there that we don't really know. Okay. All right. What about, let's do question number 2. So ultimately, the supervisor says that he would hire the candidate again if it was for the right position. What additional steps or questions would you take in that situation?
I would probably ask what the right position is, and why they felt that way. And I mean, I guess it also depends on, because it says that they didn't mesh well with other people, and whether or not that's important to the position I'm hiring for.
Right. So doing some additional research, right, and asking questions, and maybe checking with a reference that's not necessarily listed sometimes helps on the resume or on the reference list of references. Like we said, sometimes doing that backdoor check. But if we can't, just trying to understand as much as we can and get as much information, asking again, for the current position, would you rehire, and trying to get as much information. And also, like you just mentioned, just thinking about what's important for that position. Is it going to be important for that person to collaborate well, to be able to interact in a positive manner, not only with the team, but with other LACOE employees? So yes, just trying to get a bigger picture of that situation as much as possible, and doing research and really reflecting on, is this the person? Again, sometimes that person just wants a second opportunity, so we need to consider that as well. Okay, how about number 3? Yes, question. Yes. We're going to go back. We're or a comment for number 1.
So if the person initially, as you said, they check no, do not contact their employer. Okay, so as a condition of employment, you need to contact the employer, and you let them know that, right? You call them and say, I need. So
That is correct.
Then they say, okay, yes. Do you need that in writing?
If they tell you that they do, then you can go ahead and call, because you're at that point you're going to be hiring them to come to LACOE.
You
So
better hire them then, right?
so you're in the process of you're going to make that job offer, so they know that you're doing this to help them, so they can come here. Yes.
Often, sometimes, what happens from our experience is that sometimes they want the opportunity to have the conversation with their employer that this is coming, and sometimes they've waited up until that point to have that personal conversation, and just giving the employee, that potential candidate, the opportunity to do that. So that's kind of, but sometimes they're just very anxious and they continue to try to negotiate other options.
Right, that's a good point. And so there's that side, and also sometimes they do not want us to contact their employer because there is a situation there where it wasn't a good fit there, and it may not be a good fit for us either. So there's both situations that can happen.
I just want to add that I don't know if you guys remember when you're taking the oral examination with Personnel Commission. A lot of you probably don't because you've been here for a long time. It's actually there. We provide them with a form to sign, and so we do receive a release form from every candidate who come in to take the oral examination to give us the permission to contact your employer for a reference check. So it is a condition of employment.
Thank
It's
you.
there already. So actually, if you need to do a reference check, and sometimes it happened that they'll ask you saying that we need a release form from the candidate, you can contact Personnel Commission. We could find that form, send a copy to you.
Thank you.
Because application has the box, checkbox.
Can you please repeat that for us?
Surely understood what that is.
Oh,
That one we have to check with NeoGov because that is part of the application process. So it is in the application form. Yeah.
okay. Yes. Well, can you repeat the question?
Well, if it's required, maybe we have to remove the check boxes from the application that asks application to check whether they allow or disallow to contact the employer.
Yeah, my response is that the application itself, it's from NeoGov. It is a vendor-developed application form. I don't know. We could check with the organization. And my boss is in the back. Maybe he has a response for you.
One thing to consider is that some candidates may not want you, doing the reference check during the application process or earlier in the process, but might be okay with it once they're under final consideration. And so that's why we've been leaving it there and letting them know that we may reach out to past employers when they get to the last interview part.
Thank you. Okay, the third question. So the supervisor states that she will only disclose the candidate's job title, job responsibilities, and the dates of employment. What other question can you ask that reference? Yes. Would you rehire them? That is correct. You can ask that. Would you rehire them? Would you hire them and you can say what the position is here. For this position that they're applying for. You can ask that question. So we also need to consider that we do hire sometimes student workers or other employees that this might be their very first job. And so it's okay if we need to call their coach or their scoutmaster or the institution that they're volunteering for, and that's okay. As long as we do everything that we can to get that reference check done. And we know that for Personnel Commission, they've told us that many companies do have policy where all we can do is check these things. So, and if they give us that information, that's good. This is all they can do. If they don't want, if we keep calling and they don't want to give us a reference, that's not a good sign, right? Even if all the information that we can get from them is this, but they're not giving it to us. Okay. Thank you very much. If you have any other questions about reference checks, oh, yes, question.
If we do the reference check and we determine that the candidate is not a good fit and we disqualify them, do we then get like another rank, another person to interview? And is that person then not eligible for other job offers in other parts of LACOE?
Okay, so Personnel Commission. I'll have them explain the Personnel Commission rules.
It's not even my part yet. Come on, guys. Just kidding. So the truth is it depends. In our rules as they currently stand, if they've committed an action that would be disciplined here at LACOE, we can remove them from the eligibility list. But if it's like, well, I just didn't like them very much, we can't necessarily take that. We're not really guarded to remove them from the eligibility list because they did earn that spot there. And so there's some degrees to it. We'll work with you if you've got that question.
Okay. Yes, question.
For certificated, when can we do reference checks?
Okay, so reference checks can be done right before, when the interview panel makes a recommendation, right, to hire a person, then the hiring manager can go ahead and do the reference checks then. There are some hiring managers that if they're going to have a second round of interviews, before that second round of interviews, they do the reference checks ahead of time. And that's a good strategy, right? Because if you're already at the point where you're pretty sure that this person is a match and an extraordinary candidate, you want to go ahead and conduct those reference checks so you don't get to that second round of interviews and find out this person is not a match. So you can also conduct the reference checks before the interviews themselves to select candidates. So maybe you have a pool of 10 candidates, and as you're doing the paper screening, you end up with 6, but you're thinking, before going through the interviews and interviewing 6 people, let me go ahead and check some references. And so you can do that as well. So at any point before that final job offer is made. So.
And as a comment, I would be very clear with the panels if you have not done the reference checks, because that can change the outcome of what they think they picked as their first selection. And so sometimes that does create some, contention, if you will, when they find out the person we picked didn't get picked. So make that clear if you're with a panel that reference checks aren't done yet.
Yes, and that does happen. So the interview panel makes a recommendation, but the final approval doesn't happen until those reference checks are done. And then the director, division director, and the cabinet member will review all those reference checks. And then when it comes to HR, Nick and I will also do another layer of checking. Yes.
We feel very Thank you. So if we have, we're going to be interviewing an employee. We know the employee really, really well. We feel very uncomfortable about basically contributing to because there's that sheet that comes out where you have to go through and walk through. This is for certificated. So where you walk through and you provide feedback on that particular employee. Do we have the ability to see it as a conflict of interest and not contribute to that sheet that comes out where we have to put the information? Like, we're reviewing the candidates so that the interview panel can then do the interview process.
Okay, so the paper screening. Yes, so we have a paper screening form. So on that form, you can, because your comments on that form when you're doing the paper screening need to be based on, you're looking at the education, their qualifications, and so forth. So if you have reservations, you want to talk to the hiring manager who's going to be informing us who's going to be selected to interview before that person gets interviewed.
But if we don't, like, if we're going through that paper screening and we know that person really well, like we feel like it's a conflict and we've actually told.
Oh, I see what you're saying.
Right.
You
Like,
can't be
we've said
biased.
we feel uncomfortable about providing feedback on this candidate because we have they've either worked for us previously or we've worked together as a
Yeah.
and we just don't feel comfortable providing that information.
That's fine. Just the important thing is that you share that very important information and that knowledge that you have about that employee with the hiring manager so that we're aware. Because is it someone that you would not hire? Is that what you're saying?
Yeah, was
Right.
concerns about the employee, and I personally did not want to. I had oversaw the employee doing the paper screening, watching the person pop up, really not wanting to provide information, wanting the panel to be able to differentiate for themselves about the candidate, and not wanting to provide them any bias.
So share the information, definitely. Nick and I would want to know that information. And then also let the hiring manager know. So we'll work with you in that type of situation. Give us a call so we can talk you through the steps.
Okay, because
We
I,
wanna make
I
sure.
last time I contacted and they said
Yeah.
they still wanted information, and I still felt super uncomfortable about providing it.
Yeah, let us know.
Okay, I'll call you
Call
directly
me or
then.
call
Okay,
Nick.
thank you.
Yes, thank you. Yeah, so in a situation like that, just call Nick or call me and we'll help you with that situation because that's a difficult situation. Thank you for that question. That's a very good question.
Can we legally ask the former employee questions about the person's attendance?
So person's attendance. So the thing with you really should not get into that conversation because some of that could lead to workers' compensation or accommodations of some sort,
Or if we ask attendance
so
not that
is
has
this
nothing to
internal
do-
candidate or external?
Either.
Okay,
That
so if it's
has-
an internal candidate, my recommendation is that you contact Foz. Is she? Oh, Foz would be able to give you information about that, about attendance if you want to know internal. But external candidate, we need to be cautious because sometimes those, remember that protected, those protected, those conversations that protected speech and things like that, activities for the employee that's being hired, we have to be very careful not to get into conversations that have to do with illness, disability, accommodations, and those kind
So
of
we
things.
cannot ask questions about their
So no, let us know, and then we can, Nick and I can, pursue that. But it just gets challenging because if you call their previous employer, right, and they're absent, they start telling you about their person's health issues. We're now getting into conversations that they're not privileged anymore. So it's a fine line. So Nick and I, if you have suspicion that someone has had attendance issues, let us know. But internally, FOS can help you with that. Yes.
Yeah, just a comment about the previous question about calling you or Nick. I was wondering how that could compromise the objectivity of the process. If somebody doesn't want to participate, then they don't participate.
Oh, in the panel?
No, the person that asked about being
Oh,
uncomfortable,
okay. Right.
giving that negative information.
Right.
So if they remove themselves from the process, I was just wondering whether, then giving you information, that negative information, compromises the objectivity of the process.
Right. So the reason, yeah, so they can definitely excuse themselves for the process. The only reason I'm suggesting that you let Nick or me know is just in case it's the concern is something that is important for us to know in order to guide and support the interview process. Right? That's all. Just it may, of course, we definitely want to make sure that every single person has a fair opportunity to promote or to secure the job that they're aspiring to get. So we make sure that the process is equitable. However, if there's, for instance, if there's a situation that maybe we just, you want that we might want to, that's important for us to know. That's where I'm just saying might be a good idea to share with us. Yeah, but good point. Any other questions? All right, thank you very much. And again, we're here to support the important work that you do, and we welcome all your questions. So next, we have James Ebener. Please welcome him. He's going to share with us information about the AB5 independent contractor or employee.
All right, welcome everybody. Thanks for coming here. I'm going to move pretty quickly here because we're up against it. I'm going to be talking just briefly about Assembly Bill 5. This was a bill that was signed into law late last year, 2019, and it went into effect January 1 of this year, 2020. It codified a Supreme Court of California case called Dynamex versus Superior Court of Los Angeles, and it basically applies the ABC test to all of these different areas of the law: the labor code, unemployment code, the wage orders of the state Industrial Welfare Commission. Okay. So the public policy as written in the law itself is that the legislature found the misclassification of workers as independent contractors has been a significant factor in the erosion of the middle class and rise in income inequality. This law is supposed to promote workplace protections for workers who were previously misclassified. It's supposed to ensure fairness to employees who have to compete with companies that misclassify individuals as independent contractors. And lastly, and most importantly, it is supposed to ensure that the state is collecting revenue through payroll taxes, premiums for workers' compensation, Social Security, etc. All right, so it's important to keep in mind that under the ABC test, you'll have to meet each and every one of these prongs to properly classify an individual as an independent contractor. So this is important as we go through budget development, get ready for the next fiscal year. All right, so part A is the worker free from the control and direction of the hiring entity in connection with the performance of the work? Part B has to do with the course of business. And part C is whether the worker is customarily engaged in an independently established trade, occupation, or business of the same nature of the work he or she is performing for the hiring entity. So part A, it has to do with control. Again, this is a brand new law. California obviously doesn't have any court cases yet that have taken a look at the law and further defined what control looks like in California. But other states, as well as the IRS, already do have the ABC test applied. So these are some ideas that we've gotten from those other states and from the IRS. So we look at behavioral control. Does a company control or have the right to control what the worker does and how the worker does his or her job? Financial control, are the business aspects of the worker's job controlled by the payer? Is the employee or is the individual bringing his or her own laptop to LACOE, or are we providing the individual with a laptop? And then the type of relationship. Are there written contracts or employee type benefits? The usual course of business. Is the work that is being performed outside of the business's core functions? So these are from that Dynamex case. The Supreme Court actually wrote these 3 examples into the decision. The plumber who's brought in to fix a shoe store's plumbing, that's an independent contractor. The store itself is engaged in the business of selling shoes and not plumbing. A website developer who is hired to design the website for a small accounting firm, again, that is outside of the business's core function. It's an accounting firm, not a website development firm. But lastly, a software engineer who is hired to help other developers finish a project at a database company, that's an employee. That person is engaging in the same type of business that the company engages in. And then type C, is the worker performing the same work for other companies? Is that worker holding themselves out as an independent contractor, or are they holding themselves as a representative of LACOE? So if you have a division and you're hiring people to come in and give professional development, does the person say, I'm here with LACOE, or do they say, I'm here with X, Y, and Z company on behalf of LACOE? Now, there are about 20 exceptions in the law, and they tend to do with licensed positions, healthcare professionals, lawyers, architects, engineers, private investigators, accountants. There are a few more. There's also a business-to-business exemption to the law. That it's a different test than the ABC test. It's a 12-part test. That's all to say that contracts at LACOE here is developing a questionnaire for all of you, and they'll be running that by you whenever you submit a contract for an independent contractor or an outside employee or outside hire. So they'll be able to walk you through those steps. But this is really just to put it on your radar as you get ready to finalize your budgets for next year, okay? Any questions? All right, thank you all, and we'll try to wrap this up. Thank you.
Okay, let's welcome Eric Rowan. He's going to talk to us about building an adaptive workforce.
Hi, everyone. Yeah. So I'm going to try to get through this pretty quick. We do have another part after mine. Usually I like to have things interactive because I'm better at speaking on my feet than I am with prepared speeches and stuff. So I may ask for some participation. Just a heads up, Alan. All right. So I'm here today on behalf of Personnel Commission. We're really happy to be working with HRS for these management update meetings. I think it's a great way to push out information and kind of talk about the things we offer in both of our groups and stuff. Today I'm going to be talking about what is Personnel Commission's role here at LACOE. What can we do to anticipate large workforce changes and make sure that our workforce is adaptable and ready for them. Then I'll give an example about, I think, a very winning example about how we've addressed an issue in technology services. And we will talk about some kind of guidelines and some tools and tricks and stuff that we have in the Personnel Commission office to help you guys as supervisory managers. Sound good? Yeah. So our role at the Personnel Commission, we're here to implement the merit system, right? And so the merit system, it sounds kind of broad and generic. You feel good, right? But actually the merit system is codified in California Education Code for kind of giving guidelines and rules for how you can classify work and fill vacancies, do promotions, work within people's classification, and also protects you as employees for your property rights to a position, right? And so the Personnel Commission, the way we're structured, I don't report necessarily to the superintendent. I report to the 3 people who are part of our commission, right? And so they oversee all of those processes for classifying work, for hiring, for reviewing these classifications and things. And that's their role, is to make sure that we're following those education code rules, the Personnel Commission rules, and that they do also have this power to conduct hearings, investigations too, when things aren't quite going right, okay? And so that's something to keep in mind. It does work for both disciplinary hearings and also for investigations about when we're doing, desk audits and studies about are people working within their classification, right? And so when I think about my staff in the Personnel Commission office, I like to think about it as our role is to, right, that's a lot of rules, a lot of regulations. Our role is to serve as a guide to you as the managers. I mean, we do have many customers. We're interfacing with the general public, applying for jobs. We're supporting the employees at a granular level, but our main focus in the hiring processes and the classification work is working with you as managers, and we want to be your guides through all of these processes and rules and everything, okay? So we want to share our expertise in selection, classification, organizational development, and support you, because those are the things we think about every day, but you guys, you have your own specialties. We want you to focus on that. Sound good? So when we're talking about the hearings and investigations and issues that come up, one common thing that we see is that changes will come to the organization and managers may not anticipate them. They may react kind of haphazardly, or, I'm using what I've got at the moment. And unfortunately, that can lead to some problems, right? That can lead to position studies. It can be some legal action on occasion. Some people may have to test for positions. And sometimes it can even result in back pay, where it can affect your budget because we have to pay someone because they've been working outside of their classification, right? You have someone retire who has a bunch of knowledge, so you just grab someone and say, hey, you're doing this job for now. Or, right, there's a new system and there's people working outside of what was initially in their classification. If it goes for a long period of time, that back pay can really add up. So we want to help you avoid that. So typically, we like to break this out into groups and have a discussion, but I want to ask you just as a group, what are some larger issues, some workforce changes that we can anticipate that would affect us, either for LACOE as a whole or for your team individually? Let's get some hands in the air. All right.
Sorry. So technology shifts, and I know, like, for my program, we shifted into using databases, and whether or not the different classifications have to use databases in their job descriptions. So.
Right. So it could be technology shifts. It could be something small, like you're bringing in a new program that can kind of change the type of work people are doing. Sometimes it doesn't really change the nature of their work. It's a brand new tool. I think of our office when we went from paper applications to NeoGov, right, for applications. We're still just screening applications, going through the selection process and everything. Doesn't really change the nature of the work, but there's times where you may have a new database system where you need people actually in there programming, changing things that you wouldn't have asked them to do before. And that can really be something we want to address head on beforehand so that no one's working outside of their classification. It's a great one. If you're thinking LACOE-wide, think about the BEST project too. Our biggest role for a lot of districts is helping them process their human capital, payroll, financials, and all of that. It's going to be a brand new system, so it's going to affect how, and we do have a strong transition team kind of working on that, trying to get ahead of it, making sure we've got the right classifications going to adapt and be ready for that new system. Anybody else with an idea? Yes, Shirley, my plant in the audience.
Was planted. He said that, speak up. Well, as you know, LACOE has a flat budget. And so, which means that we have to do more with less. So oftentimes if you have a vacancy, you might mean to fill it, but because of budget, you may have to end up cutting it, which means that you have to redistribute duties and responsibilities. And at those times, is definitely something that you really want to consider, and maybe contact Personnel Commission to help you organize those duties and responsibilities.
That's a very good point, right? It's not only just the fact that we've got a flat budget where we may need to consolidate some work and things, but it could also be, we've got an aging workforce. People could be retiring. And so we've got to think about, well, are we going to fill that position? Is it going to look different? Are we going to try to redistribute that work? Do we need classification changes to get ahead of that, to make sure that we've got a clear workflow, clear reporting relationships, and it doesn't get really messy? Because it doesn't just affect things like pay, but it can be equity, morale, and things in the office that we want to get ahead of and make sure that we're getting ahead of and fixing. Got something back?
When talking about that, is there anything in place here at LACOE that a manager do not have the ability to just move somebody from one unit to another unit and not contact Personnel Commission?
So an administrative transfer?
No, I just say tomorrow you start doing this and you work over there. But I don't tell anybody, and I have that person working. Is there anything in place?
The
to
employee can always
alleviate
raise that to our attention.
Okay.
We do, they can submit a position description questionnaire. They can say, hey, these are the duties that have changed, and can initiate what we call a desk audit or a job study. So yes, that's definitely, and that's available on our site and the internet. Okay. So moving along, I want to make sure that Fernando's got his time, So to think about success, right, and what this can look like, we were thinking about it on our team, and one thing that happened with technology services was they came to us and they said, hey, we need some new classifications because we're going to have some new demands on our team, right? We're going to be supporting a new system. We're going to have a new system for customer support. And we've also got these other classifications that we're not going to need quite as much in some data entry type positions. And so we worked with them to develop this new classification. It's the CSSS, Customer Service Support Specialist. Last time I had a heck of a time trying to say that right. But the Customer Service Support Specialist positions were a brand new idea that we came up with them. And so in order to make sure that we could have that new system and the new skills ready, we made sure that this was a customized classification, brand new. And then to avoid the rifts and things, we had a long-term plan to make sure, give people the opportunity to gain some exposure and training to this new classification before we just went out and hired for it and potentially displaced people that weren't going to be as necessary in the new system. And so what we did, we created the new classification. We created some temporary positions, and this is something that you can do within the rules to have a limited term extra help position for 6 months or less. And we would rotate the people from, I believe it was mostly computer operators, into the customer service support specialist positions, gave them some training, let them get a feel for what this position is going to be like, and made sure that everyone went through it. And then we established the permanent positions and ran a recruitment. And one nuance about this recruitment was to make sure that we ran it not just a regular, everybody in LA County, please come and apply type recruitment. We did we did 2 lists, a promotional list and an open list, with the promotional list taking precedence. So it's essentially a message from technology services saying, we want to promote you, we want to develop you, we're going to hire from within before we go outside, right? And so that's not only good for kind of developing your staff, but it's also really good for morale and making sure that you're demonstrating these values for your group. So it's something to keep in mind. There's little tricks in there in the Personnel Commission and Ed Code rules that we can do to kind of help you kind of build that up and that sense of justice and equity in your team. So it's pretty successful. I think we hired as many people as we needed internally, and then we, from the open list, brought in more people eventually over time to help support the BEST project going forward. So pretty happy with it. And let's see what we're at time. Okay. So I want to make sure that Fernando has some time, but when you see the slides online, there are some PC processes and things that, some distinctions that, aren't necessarily clear that we can help you navigate through. Some of them including, what are the restrictions on limited term assignments or working someone out of class? If you're reclassifying a person or a position, what are the different impacts of if this was something that changed slowly over time, or if it was a sudden organizational change, because that can affect things like back pay or whether or not someone would have to test for a position, things like that. And creating new classifications. I talked a bit about, is this a change in the process but within a classification, or is this a change in the nature of their work? That's going to have different implications on the approach we're going to take. And then things like lead and supervisory responsibilities are an issue that often come up. Where there's a distinction, it's subtle but important that we have to think about going forward. And then some additional tools and considerations. Our office can offer these skills. We can help map any processes, work processes that you have going on, making sure they're running efficiently. We can take a look at your org charts, making sure there's clear distinctions between the work and reporting relationships. We can help you establish rotations and stretch assignments like we did in technology services. Yes? Well, you can contact me if you like. I'll probably delegate it down. But, but no, sometimes we really do. We sit down with the managers and say, hey, let's look at these things, make sure that we're looking at it and optimizing things. But yeah, it would probably go between our three teams, I'd say. But it'd be an analyst or senior analyst likely working with you. And then there are little nuances and things like the field of competition for our recruitments. And we can think about things like succession planning. And how can we kind of fill a role that's going to be vacant coming forward and prepare your staff for that in the long term. So the main takeaway is let's try to get ahead of these and let's work together to make sure that we're anticipating those workforce challenges and keeping our workforce flexible. Okay? Thank you.
Thank you. Thank you very much, Eric. So Fernando Acosta is going to take us through #MeToo and the workplace harassment bystander intervention.
So if you noticed, Nick never said anything about this is being videotaped. Did he get your consent to have your back of your head photographed? None. No consent, no authorization, and it's implied that you came in here. Remember, you have rights to privacy. So right now, I allowed Nick to tape me, but there'll be an injunction. The reproduction, distribution, or other use of this videotape is barred until I negotiate my royalties, okay? I'm Fernando Acosta, and I'm with Labor Relations, and I'm a lawyer. So just keep that in mind. So we're going to talk about a little brief history here, and that is, what do you think that event is right up there? Anybody? All right. So one of the people that is in that picture said something to the effect, if nominated, I will not run. If elected, I will not serve. Anybody? Lyndon Johnson? Okay. By the way, I'm still uncommitted right now. I don't know. If nominated, I shall run to Mexico. If elected, I shall fight extradition. Anybody? Okay, here's the right answer. This is the signing of the Civil Rights Act of 1964. and I ought to give credit down there. It's in the Lyndon Johnson's Presidential Library. I believe it's in the University of Texas at Austin. This is what he said, March of '68. I might have seen it. How many baby boomers are here? Okay, boomers, put your hand down. Accordingly, I shall not seek and I will not accept the nomination of my party for another term as your president. As you can see right there, Black History Month and Dr. King. So that really starts out with the March in Washington. Shout out to Sharon Harvey. And then later on, then the legislation. So the legislation is really, there are a lot of titles in the Civil Rights Act, and one of them is like Title II, accommodations, right? Couldn't get into hotel, motel if you were a person of color. So this law only has 5 protected categories, right? Race, color, religion, sex, or national origin. What do you think California has? Anyone? I need to recognize Ashland Dennison. He'll be sitting for the July 2021 State Bar. Ashland, what are the protected status in California? Huh? It's going to be in your state bar, sir. Okay. So, they've got everything in there. Wow, someone said wow? And the problem with federal law is Age Discrimination and Employment Act is a separate statute. Earlier today, somebody Americans with Disabilities Act, different statute. California says, let's put them all together and get the law firms confused and then confuse the clients. So here we go. You've got all that, sexual orientation, gender expression, gender identity. If you look at Title VII, it just says sex, right? Does that encompass gender, gender condition, genetic information, sexual orientation, gender expression? No. The current term in the Supreme Court, there are 3 cases that are being argued to determine whether or not Title VII, has all of that. So if you're California, you say, we don't care. We already provide greater protection. What's federal minimum wage? $5? What's Cal 7? What's California? We provide greater protection. Okay? So remember that. And then the because of, and there are people here in DSP, and they like to talk about causation. How do you close achievement gap? Too many variables. But because of, it's really in tort law, cause and fact. You do something, you don't do something, it causes a problem. Okay? Car accident is a good example of that. But you can be an equal employment opportunity bully. Here, all the men are told, go to work. Is there sex discrimination? Probably not. So be an equal opportunity bully. It's easier for us to defend LACOE that way. If we have to defend disparate treatment, we say, no, she didn't get treated differently than men. No, it wasn't because of their religion, right? Because of is the answer to the question, but for your race, but for your national origin, you didn't get this job. And you say, no, it wasn't that. We got bad reference. Question of fact. Who really knows? Okay, so now the big change right here. And I'm looking at my friend Robert Bailey's. You have SEIU classified staff people that are not managers and they're not supervisors. But now you're going to have to release them for 1 hour because now they are required to take the education and training on workplace harassment. As managers, we're suffered to it every 2 years. How many hours? 2. Thank you, Ms. Harvey. Now, rank and file will have to go through the training. And here's the implied premise by the legislature. If we do education and training about sexual harassment, what is the outcome we seek? Shirley? Greater understanding? Okay. Anybody want to do a SMART goal on greater understanding? What would that look like? No one knows, but we're going to do it. So now, if you haven't done it, calculate the numbers. How many staff classified we have that's going to have to be released for 1 hour? That's the Me Too movement. Here's the other one, the Me Too movement. The NDA. In the debate, Senator Warren asks Mayor Bloomberg, would you release the people from an NDA agreement? Robert is shaking his head. You cannot have NDA agreement because what happens, according to observers, it perpetuates because those persons can't testify against. So we don't have non-disclosure agreements in the first place. And it's a little bit different for us. And then the other one is, you were talking about reference. You know, by the fact that you say something about somebody, the fact that you don't include other relevant evidence is also a liability. Okay? So if you look at your handout on reference check, second page, Randy W. versus Mooroc Unified School District. If you have a highlighter, highlight that. The 1977 case, Randy W. is a victim of a school district. Mooroc Unified School District is the district that this school administrator used to work. He left because of some allegation of sexual misconduct. So when the new school district wanted to hire him, they call up and, what's this guy like? Nah, well, he's okay, not a problem. Guess what? What does he do at Mooroc Unified School District? Repeats the same thing. Now, so that gets into the duty issue, but it's also important what you say and what you don't include. So here, in addition to the Civil Code section on 47C on immunity, the legislature says, go out there. Tell them that principal from Miramontes, LA Unified, molested kids. It's factual. Okay? Third one. The non-disparage agreement. We really don't do that, but I do know a former school psychologist said LACOE is a bully, and she wrote about it. You can buy her book at Amazon. If she settled, we could have said, by the way, stop publishing the book. She holds the copyright. Don't sell it. There's no nothing reproduced in that book. So the non-disparage treatment is also forbidden. And how many of you really would disparage LACOE after you're gone? Ashlyn? No, I'm kidding. Okay, more Me Too movement. This is a problem for HRS, a change in the law, because it used to be that the way equal employment is that if you're being harassed, then it's going to alter your working conditions because you're an unhappy employee and you're going to be unproductive. So they eliminated that. A single incident of harassment has to be severe and pervasive. Even a comment, one comment, may put us on the hook, okay? Isolated remarks. So when Nick says to me, Fernando, are you thinking about retiring in the Philippines? I go, Nick, why are you asking? Nick? And he does it during budget development. Ever notice the timing of that? Mr. Bayless. And here's the one that's really rarely appropriate for summary judgment. What the heck is summary judgment? Summary judgment, you file a complaint, employer or defendant answers, and then they go through a discovery. God, Ashley's just shaking his head. He really loves this stuff. Depositions, discovery. And then it's usually the defense files for summary judgment. And the theory is, supported by the discovery, no genuine issue of tribal issue of fact. And if you're a defense attorney, that is great. If you're Atkinson, Andelson, that is great. You got summary judgment, the case doesn't go to jury. The legislature says it's not appropriate for summary judgment. Yes, we have I got a 2-minute warning. So, it's going to get messed up at the parking lot, but that's okay. And then it used to be that if you're a defendant, you win the case, right? A trial, and then you're going to recover your fees against the claimant. Well, legislature said you got to have a really frivolous complaint. The fact that you survived summary judgment and you're in the trial, there may be some real question that it needs to get tried on. So we are now doing some investigations, and we're going to apply the standards here. And in the olden days, I can tell you, the standard was severe and pervasive, right? Affects their terms and condition. I will not use that standard anymore. The other thing about the Me Too movement is AB 9. This is a problem for everybody, and that is it's a 3-year statute of limitations. It used to be 1 year, now they have 3 years. But you know what? If I ask Robert, 3 years ago, Robert, how many martini drinks you had at Downey Landing? There you go. He didn't remember. I'm kidding. Ashland, I set him up for this. There's a no rehire agreement. I got 1 minute. Why would you want to come back? You sued LACOE and you want to come back? Why would you come back? Sir? You sued LACOE. Why would you want to come back?
The Martinez at Downey Landing.
Yes. But better yet, this is what I tell Nick. Nick is my 7th supervisor in 14 years. How long is he going to be here? A year. Once he's gone, I want back in. If you're McDonald's and the agreement says no franchisee anywhere, it's a job in Oslo, Norway, no rehire. Weird, but it is what it is. We don't have a rehire clause, and that also applies in workers' comp settlement cases. I will tell you, before Me Too movement, no rehire. You can't even come back as an independent contractor. You even can't come back if you change your name, change your gender. We don't want you. What part of no you don't get, big lug? Now, the bystander intervention. Isn't this great? Thank you. Hold the clap. So, 2016 EEOC. Part of the Title VII is establish Equal Employment Opportunity Commission. It administers, it enforces, and regulates Title VII laws. And they came up with a report. And in this report, everybody knows that sexual harassment is underreported, and part of the reason is the bystander training. I think you and I, if we see a baby in some parking lot, unattended, and it's hot, the windows are up, probably some obligation. And Robert is one of those people that will probably call the cops. But does he have a duty, ladies and gentlemen? Ashland? Legal duty to call the police. No, exactly. Europeans hate us for that because we don't do anything like that. And that's that classic case, I don't know, Kitty Genovese in New York. She's, bludgeoned in an alley. Nobody called. But here they say one of the things that would prevent sexual harassment is bystander intervention training. And we will be required to do that because now, first of all, we're required to do it, but we're smarter than most people. We've already made it a mandatory obligation, okay? And believe me, we do take disciplinary action. If you saw something and you didn't report it, I will tell you, we do take action. And so this is now providing bystander intervention. So I'm purchasing I'm going to send out an RVP, request for proposal, help us do the bystander intervention. And we have a volunteer. Come on down.
And I always wanted to know if, and it's only probably like 1% of the people would ever be affected. If you're on a campus of another school district for some reason, and a fight breaks out among the kids, do you have a duty to try to stop it?
Where's my Southwestern third-year law student? Pay attention. The answer is no. That's my take. But here's the deal. The mandated reporter, if you look at that statute, it probably says it's within your jurisdiction. But you probably if you're there, are you there on business or you're there on business and you see something? I would probably err on the side of caution and report it. No, forget the intervention part. Workers' comp, if you get injured, you got your butt whooped, workers' comp isn't going to protect you because that is not scope and course of your employment. Now, if you wanted a referee, no, that's a different story.
Why isn't a baby in a hot car a mandated reporter incident?
Simple answer, no legal duty. That's a law. They imposed that. The legislature imposed duty. If the legislature doesn't impose duty, you have no legal obligation. Okay?
So I do have a legal obligation or not to report if I'm in a parking lot at LACOE and I
None.
see a baby in there?
None. Zero. And you go through the analysis. The way duty sometimes gets looked at, you're going to have workers, employers, right? Then you're going to have special relationship duties. You have no duty to the kid, to the parents, and the owner of that parking lot. You have no legal duty. I got zero. Anybody for martini lunch? Are you inviting me? Wait a minute. Okay, if you're really chicken ass and you don't want to call, you don't want to bring it to your, you see something, like she said, call the hotline. But please, don't call us and say, Fernando's photocopying his tax returns. Really? Fernando took a box full of staples. Really? Mary came in late. Really? Fraud, defalcation, things that really matter. And the shout out to Sharon Harvey Leadership Conference. And this is her work product. Do you recognize this, ma'am? You do? It's been marked as Exhibit A, identified and accepted. And it says change maker, and you open it, guess what? It's the man in the mirror, and then she cues up Michael Jackson. Okay? Isn't that great? And if you talk about the Jacksons, ABC, Jackson 5, ABC, and then Janet Jackson, Control. Those are your monikers to remember ABC 5, the Jacksons.
Thank you, Fernando, for your presentation. Thank you.
Trust me, I'm a liar.
Thank you very much for your presentation. Thank you, everyone, for joining us today. We do value your feedback. I sent you an email with the survey link, the link for the survey. You can also use your camera to scan this QR code and give us feedback. We do design our trainings based, our professional development based on your feedback. I would also like to acknowledge all the presenters. They did an outstanding job today. And also we had some staff who came to help us early, and Crystal and Miriam and Diana. So this would not have happened without their support. So thank you, everyone. Enjoy the rest of your day. And happy Friday.